Good morning, good afternoon, and good evening, ladies and gentlemen. Welcome to the webinar titled Mediation, an Asian Perspective on International Mediation, jointly hosted by Singapore International Mediation Center, SIMC, and Korean Commercial Arbitration Board, KCAB International. Today's webinar is one of the official programs of Seoul ADR Festival to be held until this Saturday. Almost a year, lots of local and global companies are suffering seriously in their core business due to COVID-19 pandemic. However, it's quite difficult for them to trigger litigation or arbitration proceedings by their own initiative because it's also tough to estimate or forecast the outcome of proceeding and next step, even having favorable judgment or award. In this circumstance, it is quite unsure who would be defaulting party and whether he should be fully responsible for the whole damages or claims. Then, how do legal professionals such as counsel, arbitrator, and mediator help our friends and clients to overcome this crisis efficiently and appropriately? Today's webinar has been designed to provide a way of resolving dispute, not to winner-takes-all approach, but moving forward together concept, quite often mentioned in the Asian cultural text. Therefore, today's topic, Mediation, is not a typo. Without further ado, I would like to invite Professor Hi-Taek Shin to deliver his welcome remarks. Professor Shin is the chairman of KCAB International. He also serves as a governing board member of International Council for Commercial Arbitration, ICCA. He recently retired from the Seoul National University School of Law, where he taught international business transactions and resolution of commercial and investment dispute arising from cross-border transaction since 2017. Prior to moving to academia in 2007, he was a partner at Kim & Chang, specialized in merger and acquisition, cross-border investment, and the resolution of dispute arising from cross-border investment project. He regularly served as an arbitrator, both in international commercial arbitration and investment treaty arbitration. Professor Shin, please, 의장님 부탁드립니다.
Good afternoon, everyone. On behalf of KCAB International, I am pleased to welcome all of you to this webinar. We at KCAB International are very pleased to offer a forum for discussing an Asian perspective on international mediation with our dear colleagues at Singapore International Mediation Center. I would like to extend my sincere gratitude to Mr. George Lim, Chairman of SIMC, for joining us again in this year's Seoul ADR Festival with this wonderful program. I would also like to extend my appreciation to our distinguished panel of speakers today, who have graciously shared their time and expertise with us. Special thanks go to the staff members of SIMC and KCAB International for their extraordinary support in organizing today's webinar. As Mr. Kwon said, those engaged in international business transactions around the world face serious difficulties in performing contractual obligations due to the various constraints imposed by pandemic for almost a year now. The lingering uncertainty caused by COVID-19 leads us to look for an amicable resolution of disputes between business partners, which would not put their long-term business relationship at risk. In particular, when the external causes, such as the pandemic, not the parties, are to be blamed for the failure or delay of the performance. In this regard, today's webinar is very timely and meaningful. Like other Asians, Koreans value relationships highly and consider resorting to litigation or arbitration only as a last resort. This cultural background makes mediation as a preferred means of resolving dispute for Koreans, like other Asian colleagues. Mediation has drawn increasing attention in recent years. As Singapore Convention on Mediation came into force September this year, I expect that it will draw more attention in the upcoming years. Korean government has kicked off a task force to review and address potential issues associated with the ratification of the Singapore Convention on Mediation. Once the Singapore Convention is ratified by major economies, the role of mediation will be boosted as a preferred means of resolving international commercial disputes. For years, KCAB has annually handled thousands of court-connected mediation cases. It is in the process of upgrading mediation rules specifically tailored to international mediation cases. KCAB is committed to continue to provide efficient and affordable mediation services grounded on our long experience dealing with domestic mediation cases. We sincerely ask for your continued attention and support in this regard. As the global pandemic has apparently increased attention to and demand for mediation, we hope this webinar today serves to shed light on mediation as a reliable dispute resolution method in Asia in the post-COVID-19 era. Our expert panelists will offer hands-on expertise and experience on resolving various cross-border disputes through mediation in Asia. Finally, I hope you also enjoy other diverse events taking place during this Seoul ADR Festival Week. Please stay safe and healthy in these turbulent times with virus and violence. Thank you very much.
Thank you, Professor Shin. I think it's just Professor Shin is currently having a hard time to manage the whole Seoul ADR Festival Week. But however, yeah, definitely just Professor Shin is the most busiest gentleman out of this community. But however, Professor Shin mentioned that he has 4 more days he should be on screen or in person. Next, I would like to introduce another busiest man in arbitration community in Korea, Mr. Kevin Kim. Kevin Kim just will be today's moderator. Mr. Kim is a senior partner at Peter & Kim in Seoul. He was previously a senior partner at Begiman Lee LLC, where he worked for the past 3 decades in various roles, including as the co-founder and head of international arbitration practice and the head of domestic and international dispute group. Among other positions that he holds, Mr. Kim is presently chairman of KCAB International Arbitration Committee and board member of SIMC. Okay, Mr. Kim, please. 김가비 변호사님 부탁드립니다.
Yeah. Hello, everyone. I'm very honored to moderate this session. Actually, we originally planned to have session 1, 2, and 3 on the several different topics, but all these topics are related. So we decided to just consolidate the a session 1, 2, 3 together is more interactive way. So let me introduce the panelists in the 3 sessions. There is no particular order, but based upon the pictures, which I try to introduce George Lim first. George Lim is Senior Counsel and Chair of Singapore International Mediation Center and the former President of Law Society of Singapore. He's a leading figure in Singapore in any area, but he is a quite leading in mediation. I want to call him as the grandfather of the mediation in Singapore and Asia, but he looks too young to be called as grandfather, so I'll call him as father of mediation in Singapore and Asia. He has a great experience, and he's a full-time mediator. He already mediated about 500 disputes. And the amazing thing is his success rate of the mediation is 75 to 80%, which is amazing record. He served as first chairman of Asian Mediation Association and currently sits on board of International Mediation Institute, this global body promote professionalism in mediation. My second panelist is Yu-Jin Tai, his partner and the head of international arbitration, the Mayer Brown LLP in Singapore. He is heading the firm's international arbitration practice in Asia, and he actually practiced in Singapore, London, Paris, and Washington, D.C. over 20 years, and did the numerous international arbitrations. He also participated various mediation matters, particularly recently, and he was listed so many positions. For example, he was listed in Global Arbitration Review 2011, Global 45 under 45, and he was listed numerous the recognitions in the various positions. And in May 2019, Yu-Jin led his team to winning the Financial Times Award for Most Innovative Dispute Resolution Team in Asia Pacific. And he's now serving as Vice President and Fellow of the Singapore Institute of Arbitrators and take other positions. We also have the Korean speaker, which is I will call him Judge, but it's Mr. Junsang Lee. Mr. Lee is managing partner of Yoon and Yang. As you know, his main practice area is international arbitration and litigation, and the civil or the criminal litigation, insolvency, and other matters. He served as judge from 1994 to 2013, so almost for 20 years he was judge. He served as presiding judge in the Korean court, and he studied in UC Berkeley, and he served as a mediation judge from 2002 and 2003, and the government delegate to the Vienna conference in Institute Working Group. And he also have, I have the list of his recognition, was almost a page of the international recognition. So with this introduction of the panelists, today we are going to discuss what is mediation like in Asia, and particularly during this pandemic period. So I would propose a question to the panelists, and panelists will answer to my question. by introducing their experience and their thought about the mediation in Asia. So let me start with the question to George. George, I understand you have extensive experience in mediation in Asia. Could you share your experience in mediation, particularly in Asia? George?
Okay. Thank you, Kevin, for that introduction. Annyeonghaseyo. And I would first like to start by thanking KCAB, Professor Shin and Mr. Kwon especially, for inviting SIMC to co-host this webinar. You know, the topic is about mediation. And if you think about it, mediation is really very Asian. That's why sometimes we say that the word mediation, if you spell it the English way, but if you spell it the Asian way, it is mediation. Because, you know, in the old days, let's think about it. In the old days, how did we resolve our disputes? The Chinese used to have their village heads, right? Settle their cases. Indians had the panchayat system. The Malays, you know, it had the penghulus, the village chiefs. And in Korea, I'm sure you had the same thing. You know, because of the pandemic, I've been watching a lot of Netflix, and I've just finished 6 Flying Dragons. I don't know how many of you have watched that, but it's a Korean drama, and it's about the Joseon dynasty, how it got started. And correct me if I'm wrong, but fast forward, I think you had the Japanese come in, then you had the Americans, and now you have a very litigious kind of way of resolving disputes. But Junsang, I think you can tell us more about this, because I think within the Korean community, you still have the village heads, clan leaders resolving matters. So that's really very Asian for us. And for me, this is very ironical because, you know, for us in Singapore, we had the British come in, introduce a common law system, the court system, and then we had independence. And then we now have the West reintroducing mediation to us. I mean, for the US, it was in the 1980s, for Singapore, the 1990s. So we're like turning the clock backwards. But the good thing is, I think we are rediscovering ourselves. So for me, I feel very strongly at the Singapore International Mediation Center. I think, you know, we focus on cross-border disputes. This year alone, we are doing, I think we'll hit more than 40 cases, all right? International cross-border disputes involving Asian parties, many of them Chinese, Indian parties, and Western parties, US. So we got quite a fair bit of experience now mediating these type of cases. And I can say that it needs a slightly different perspective and skills to handle mediations involving Asians. I think for us, there's an advantage because, you know, Asians, and it's not to say that the other people, the Westerners or the Europeans, do not treasure these things, but Asians, we treasure a few things a bit more. For example, I think you can see that there is a greater expectation on the mediator. I think the Asian party would want a mediator to be more active, sometimes even evaluative, but we are fairly careful there. Face saving is very important. There are many cases, and it's not that a Westerner would not feel that face is not important, but I think for Asians, face saving is really very important. The respect for authority, hierarchy, these are things we take into consideration. And I like what Professor Shin said just now about relationships. Okay, Asians care a lot about relationships, and this is really the value of mediation, because we have a chance to preserve relationships, and if we can bring that into a mediation, I think, you know, it really helps. Present relationships, future relationships, and one last point, I think, which we all believe in, is harmony, right? I think Confucianists, Buddhists, Christians, Hindus, we all believe in harmony, and this can come in very strongly in a mediation. So these are just some of the pointers I like to introduce. What it means is that if you are a mediator involving an Asian party, or if you are counsel representing an Asian party and you go for a mediation, I think there are different ways to prepare it. And this is something which I could touch upon later, but maybe pass the floor back to you, Kevin, first.
Thank you, George. It's a good start. Yu-Jin, I understand that you recently have a specific experience in the SIMC mediation wholly virtually, so it's virtually only. So could you share your experience with the SIMC mediation in a virtual way?
Yes, thanks, Kevin, and thanks SIMC and KCAB International for having me. Yes, it was, we had a mediation a couple of months ago, and it was an energy sector mediation that was in relation to a dispute that was governed by English law and subject to arbitration in London. One side was an Asian energy company. So to George's point, this qualifies as at least half Asian mediation. The other side was a global energy company. What was interesting though, and we can discuss this later, is that ironically, the Asian party, I think, behaved in a very international way. What was interesting about this dispute is that as is typical in energy cases, it was high stakes. It was quite technically complicated with regard to those issues that the parties had to bridge. And so even though they had bilateral negotiations towards settlement, these negotiations were getting them nowhere and they were heading towards arbitration. And then towards the end, we decided mutually that we will try for a facilitated form of settlement, namely mediation, to see if we could specifically bridge those technical gaps. So the technical aspect of the dispute was important to the mediation. Because they were the early months of the pandemic, I think it was around April, we started talking about this, and April to May, we did the mediation in June. So travel was not possible. Remember, I told you the arbitration was seated in London, so there was no connection to Singapore. But we ultimately ended up with an SIMC arbitration. We had to conduct it on Zoom. It involved 5 locations. The mediator and one of the parties was in London. We had other representatives in Geneva, in Dubai, in India, and in Singapore. We set ourselves 5 consecutive days to deal with it. But because of the time difference, we essentially mostly had about 6 hours of airtime a day. We would start late in the afternoon Singapore time, and we would run pretty close to midnight. And I think on one of the days we went past midnight. And because there are a lot of hours being spent in front of the screen, it was slightly more intense than in real life.
Okay, thank you. What I want to ask the Junsang about the situation in Korea. Is there any, do you have any particular experience, particularly in recent years?
Thank you, Kevin 변호사님. As Kevin introduced me, I served a mediation judge almost 20 years ago for 2 years. And I totally agree with George Lim's understanding about Asian culture, looking at mediation. As you mentioned, the situation is the same in Korea. And so the village elders always assist the dispute between the village people. That's a very good tradition to Korean. And also in court cases, the same situation happens repeatedly. When I was in court, I watched a lot of cases that even though claimants seek a lot of money to the defendants, defendant seek a counter claim against the claimant, but if they meet face to face and mediated by the court judge or a mediation judge, they, at the end of the settlement, they sometimes they mention that I only ask his or her apologies of this case. I don't want money. So that's the basic cultures in Korea. So I see that those phenomenon is kind of the many Koreans' mind. So there's a widespread culture in Korea. So that's very friendly to mediation. And one point I want to mention that in terms of mediation in Korea, those mediation procedures are started by court judge or the administrative body. So we have some kind of a law like a Civil Mediation Act, and those acts can activate mediation with regard to court cases or the cases regard to government. So, but Singapore Convention is somewhat a slightly different definition of mediation. So in the future, I believe that, or I hope that those basic ideas about understanding of mediation in Korea can lead to a very independent and privacy respecting mediation procedure in the future. There's somewhat challenges to be overcome in the future. That's my point in this question.
Thank you, Yu-Jin. Yu-Jin, going back to your experience in the virtual hearing, is there any difference between the virtual hearing, the virtual mediation versus in-person mediation? Because many people believe that the mediation is more like personal exercise. You are supposed to have face-to-face meeting rather than the meet on video. So what your experience?
Well, to be honest, it was my first experience of a partly or fully virtual mediation, and having attended George's course, mediation course, I initially was quite skeptical as to how effective it could be in a completely virtual setting, given that one of the key things that the mediator is to try to do in the early stages to build rapport, and it's possibly difficult to build rapport without being in person. But I think there are a few learnings that I'd like to share. And the first point is that my takeaway from the experience is that virtual mediations, even completely virtual mediations, can be as effective as in-person mediations. And I think what is key is obviously not just the quality, experience, and skill of the mediator, but what is key is the same as in real life in-person mediations, namely the parties must be prepared and the parties must basically have a conviction to want to settle. So if these three things are aligned, then whether you're virtual or in person actually ought to make no difference. The second thing that I thought was very interesting is that my experience of virtual mediations will impact post-pandemic what I expect of in-person mediations. And what I mean by that is there are certain advantages of the virtual or the technology-assisted aspect of mediation that I think we can use anyway, even if we could travel. And the first was in relation to convening the mediations and conducting the mediations. So the virtual mediations can be very quick to convene. Even though in my example I gave, there were parties in 5 different locations. Just imagine how long it would have taken us to arrange for everyone to be in the same place in person. We were actually able to organize a mediation within something like 2 to 3 weeks from the point where we agreed SIMC was going to do it. Or rather from the point in which we agreed SIMC would do it and we had shortlisted a mediator. So that's really quick for a large mediation at short notice with so many parties. The second thing that was interesting is in complex mediations, in fact, it's not just like community mediation or mediation between, in less complicated situations. There's some mediations where, because they're so technical, you have to exchange a lot of documents. in order to get to the term sheet. So you're dealing with things like pricing, analysis, financial modeling. And with the virtual mediation, we were able to set up, with SIMC's help, a document protocol, a document exchange protocol, which is very useful because if you think about it, when you're in an in-person mediation, normally what you would do is you'd be stuck in the room with the mediator for many hours. You would bring copies of these materials. You usually be handing out the materials hard copy. In a virtual setting, we simply cannot hand anything out hard copy. So we are able to exchange the native formats. And that's quite useful because you can actually get the parties to go away and do their homework. And in a virtual mediation setting as well, instead of having very long sessions together, there is a tendency, because it's so intense, for the mediator to break up the sessions into 1 hour, 1.5 hour chunks. And when you break up in many chunks like this, you alternate between private session, joint session, private session, joint session with breaks. The mediator is able to assign homework to each party to go away and do. And the feeling is that when they are able to do this in their own setting with their office support and so on, that they are more likely to do it and they're less likely to give an excuse. And I think the final point, which is very key, and there's a bit of a plug for SIMC, I think the fact that we had SIMC do it contributed a lot to the success. In a virtual mediation, it's very important for the mediator to focus on the job of mediating. And so you need a full-time support from an institution that is dealing with all the technical and the logistical aspects, like telling parties when you come back, sending them to their breakout rooms, going back and forth to the private session and to the joint session to say, how are things going? Should you go and take a break? And SIMC was able to provide us with a full-time director who was essentially, we have an arbitration tribunal assistant, was essentially an executive assistant to the mediator. And that made a huge difference. And I think in retrospect, the parties are very happy with that because, as I mentioned, the arbitration was London. Initially, they considered institutions in London, but they ultimately picked SIMC because of SIMC's experience.
Thank you very much, Yu-Jin. Maybe we just go back to more fundamental question. How could we make this mediation successful? Because now we actually, Yu-Jin confirmed that the virtual mediation actually work with the good technical assistance from SIMC. So maybe I can ask George and Junsang, but from the mediator's point of view and the council's point of view, how could he make the mediation more successful? Maybe I can start with George. George, you have tremendous track record of successful mediation. So what is your secret? Could you share your secret with us?
I will share anything with you, Kevin, and with my friends here. Yeah, mediation to me is really about people. It's about how to get people to look at the problem openly, honestly, and take ownership of the problem and take ownership of the solution. That for me is the beauty of it. And I've been a court lawyer for 38 years, arbitrator as well. But for me, mediation gives you this other perspective. It humanizes the process. The law is important, the legal rights are important, but we go beyond that. We look at each other as people. So in any mediation, if you ask me, how do you prepare involving anybody, but in particular Asian parties, I think it's the importance of connecting, of finding that way to connect with both parties, but still assuming a neutral position. So for me, one key thing is preparation. I do a lot of preparation before the mediation. It's not just reading the mediation statements, which I ask parties to send to me, at least 2 weeks or at least a week earlier, so that I know the basic facts, I know the issues. But I actually contact lawyers beforehand, before the mediation, and sometimes we have even a joint call. But I find the private calls I make to lawyers so important because they tell you nuggets. Okay, these are confidential things. And by the time you come for a mediation, I know the issues, okay? I know the issues, and you're trying to find out what is it that's needed to turn the mediation, all right? To get parties, who have been fighting for 2 years, to get them to resolve the matter. So that's really the amount of thinking and preparation. And the other pointer is really building rapport. So don't be in a hurry. Don't expect to get your solution at 11 a.m. in the morning. It doesn't happen, okay? I take the morning to actually try and build rapport, connect with the parties, and find ways to do that. And I start my mediations with a private session with each party first, not with a joint session. So for me, I've learned that is so important. When you go into a room, a separate room, the breakout room, speak with the parties, connect with them first, 5 minutes, 10 minutes. They will feel a lot more assured when they go into the joint session. And that's how they size you up as a mediator. And in the end, for me, the key is sincerity. It's the parties must feel that you are really there, genuinely trying to help them solve their problem. And if you can give that impression, if they feel that way, half the battle is won. So for me, preparation and building rapport. I could say more, but I don't want to, maybe the others want to add on. Yeah.
Thank you, George. Actually, my experience, personal experience with the mediation, we had a mediation in London, and I'm quite impressed by the mediator. Spend a lot of time in advance with parties, and separately with parties and together with parties, and all procedural matters, and hear from the parties that what is a position, what is a concern. So spending more time with parties in advance will enhance the possibility of good mediation. So Junsang, what is your experience and your recommendation to make the mediation more successful from the, of course, you can share your experience as a mediator, but also share your experience as party representative.
With regard to that question, I would like to mention 3 points. First one is we can, as counsel, urge or recommend the client that the mediation can be a good way for them to get an objective view of their case. Through discussing the other side with the help of a mediator, they can get an objective view of the case. In the routine arbitration or litigation case, they only try to keep their position to win the case. So sometimes they miss the weak point of the case, and so that could be one good aspect of mediation. And second one could be a business perspective. Once the mediation starts, they put all issues on the table, including the matters of the case and other potential matters of the case or business relationship between them. And they open the gate to talk about all issues arising the business relationship between them, and they can settle once at one time without the need of the suing another following cases. So that's the very effective and efficient way for them to keep their relationship very peacefully and business friendly. And the third one could be the cost-effective aspects. As Yu-Jin already mentioned, there are the virtual online mediation could be the one way that to save cost. Sometimes my clients ask a question to me that we need to accept the mediation process against the other party because they can go abroad and they prepare the mediation for several days, and that's make a lot of cost to them. So if they pay to the seller, what is the cost value? So, but if we use the virtual online mediation, we can safely say to a client that with a very little cost, we can enjoy the mediation process freely. That's one strong point, I guess, to make mediation successful. That's my point. So that's the
Thank you,
issue.
Junsang. Actually, we have the question from the floor on this particular point. And the question is, in Korea, we witness very low percentage of acceptance by the other party for the invitation of mediation process. Yes, I think, but I would a bit disagree with the recent development with my recent experience in the mediation, because several arbitrations I practiced last year at least, we went to mediation in the course of arbitration. At least the 4 cases I had mediation in the course of arbitration, or just before the arbitration. And then the parties have quite good experience, and then some cases actually settled. I understand that, of course, Junsang and George and the Yu-Jin, you all have experience with the Korean parties in the actual mediation cases. Could you share your experience? What is the Korean party's reaction about this mediation? Junsang, you wanna share your experience first?
Yes, as I mentioned before, the Korean parties are traditionally very friendly to mediation in domestic mediation, but in terms of international mediation, they have somewhat concerns. But due to the recent development of international mediation, like the Singapore Convention, they feel more comfortable about the mediation. So usually the Korean parties are very sensitive about the cost and result of the mediation. But even if it fails to reach the settlement, I usually say to the client that even if it fails, you can get a lot of information. You can fully understand the other party's position, and on a legal side, on a legal basement or a business basement. So you can get a lot of benefit from the mediation. So you need to participate in mediation very actively. And so those through those discussion, Korean parties are generally amenable to mediation steadily and growly. That's my observation so far. So if the result and the experience are more known to clients, probably the Korean parties are getting more active to accepting the mediation process in the near future. That's my simple observation. Yeah.
Yes, George.
Yeah, Kevin. So I just did a mediation last month involving a Korean party. So I share your sentiments. I think Koreans are now warming up to mediation. Professor Shin, I think 5 years ago when we came to Korea, it was to Seoul. People were interested a little bit, but it was a bit lukewarm. What's mediation? But today, I think your Korean legal community is a lot more alive, a lot more open to doing mediations, and we see that happening on the ground. If you ask me, back to that question about mediation and the Asian way, for Koreans and like for many Asians, trust is very important. Professor Shin, agree? Right? Building trust.
Yes, I agree.
So,
I think one of the reasons why Koreans rarely used mediation in the past was really lack of trusted middlemen. And while I was practicing lawyer, usually in the very early stage of dispute, the parties really wants to find somebody who could play kind of mediator or facilitator who could narrow the gap or narrow down the dispute. But at that time, while we could think about very reputable person, but those people are not really properly trained as mediator and do not quite clearly understand the role of mediator, what to do and what he should not do. So sometimes the middleman, the reputable man, in a sense, mess up the case or exacerbate the bad feelings because he always thinks about, he always come up with very presumptive proposition, or sometimes he is very intrusive. So I think that that kind of threat or caution works very well if it is said by the judges. But if this is primarily the private mediator, really we should find the right mediator. I think that from that perspective, SIMC's initiative in making mediator very professional and trained and follow the certain standard, that's what has been lacking in Korea. And I think that's why SIMC is being paid much attention and maybe is attractive option for Korean and also other Asian potential users.
So thank you for those comments, Professor Shin. And you know, for us in Singapore, for me, it is a collaboration with KCAB. We don't do this alone. When we come to your country, we respect your people, we respect your culture, we respect you all. And I like to, I mean, what we do today is really to share our experience in a very Asian way. And whatever experience we have, we're not here to brag or to boast, but really to share that experience. And you know, we've had talks before. Anytime, you know, if there are things we can do together to promote mediation, to promote peace or harmony, and we are very willing to do so, and we do it together.
Yeah, certainly.
So coming back to the point, Kevin, sorry, we've hijacked it a little bit, but I was going back to the issue of trust. And for me, when you have an Asian party, try and build that trust a little bit before the mediation, you know, your private calls to the lawyers or to the parties. And at the mediation itself, spend more time just talking and trying to relate. I do a longer joint, for example, my joint opening session. I you know, parties know I do a longer one because for me, you give the Asian party a chance to size you up, to see whether you're someone he can trust. Sometimes now with virtual mediations, we are learning new things as we go along. Professor Shin, you know, COVID-19 is horrible, but it's forced us to do certain things. So like in the old days, you know, Koreans, Japanese, Asians, it's very hierarchical, right? Sometimes you have a big company, they will send some middle manager. And in mediations, we want to make sure that there's the person who can decide how to settle that case is present. Sometimes you cannot have him present, but with Zoom, with virtual mediations now, that's possible. So in that first private session, I will meet, let's say if you have a meeting face-to-face, I will invite his superior, his CEO or his director to come and meet us on Zoom. And then, you know, when you have the camera, if I can sit next to that person, the representative, the manager, and his boss sees him sitting next to me, they feel a lot more comforted. You know, you're not against me. So we learn things like this to make people feel comfortable. And even if you have 15 minutes of that, like 5 minutes of that CEO's time, in the course of the day, when you want to decide, if we can bring him on again, I think you have a better chance of settling. Because otherwise, the Korean manager comes and says, I've got a mandate. This is it. I cannot move. But I say, okay, let's talk to your boss. And we can do this virtually now. So actually, online mediation has allowed that to happen in a sense. That CEO can still sit in his office wherever it is, and you can still try and reach out to more people and build that trust or rapport. Thank you, Kevin. Yeah.
Thank you, George. Yu-Jin, actually, you can answer to this question. And then actually, I added one more question. Now, many people are wondering what is the outcome of your case in Singapore, the recent case, actually, whether it's successful or not. If it's successful, probably parties quite happy. If it's not successful, how did the parties feel about the result?
Okay, I'll come to that second question. Just to tail end, it seems there are a few questions asking all about the same thing, which is not just in Korea, but elsewhere as well, how to encourage parties to voluntarily accept mediation when it's not mandatory in the contract. And this is something that actually, interestingly, George, I'll share with you too. Before SIMC, there was SMC, and for the last 20 years, Singapore has been trying to promote mediation, and it's all culminated now in the Singapore Convention, which is great. In my last 2 decades plus of work, I've actually been a skeptic, because in the very large cases, I've always felt that if the parties had a heart to settle, if they were convicted, motivated to settle, they already have their settlement discussions. And in fact, even in cases with Kevin on the other side, we have settled cases without mediation, right? So many Korean parties do talk about settlement. So what is it that the mediator brings to the table? And I think there were 2 things that changed for me this year. Well, maybe more than 2, but I think 2 of the key things. One is really, as Junsang mentioned, the mere fact of this global treaty, the Singapore Convention, has allowed the lawyers to talk about mediation in a new way. It just becomes something that's current. The second thing that happened, I think, is that, partly with the pandemic, there are more disputes. And also with the lawyers who've attended and participated in various mediation workshops and so on, there's a little bit more understanding of how mediation could work. So my answer to the audience who are asking this question, speaking from my own experiences, and that's why we're all here sharing this, the more you understand about the possibilities of the process, the more you can understand about the different ways to seek value in the process, the more you will be able to explain to your clients how it will work. And of course, it's very different. Every mediation can be more different than an arbitration, but it's all about, as Junsang says, seeing the value. So most often your clients will ask, if I invest, how much time must I invest in mediation? How much money must I invest in mediation? Who has to be involved? How much material do I have to reveal? What happens if we don't settle? What happens if we settle? So you must be prepared to answer all these questions. And if you can, and you can see value, then I think the parties will come to the table. So my client, it was an easy sell for mediation, partly because the 2 energy companies have had mediations before. So they have experienced mediation in London before, they know how to do it. The difference for us in this case was purely choosing the center, dealing with the fact it's virtual, and dealing with the fact that it's very technical. So even though we had an Asian party, we wanted a very, as Junsang mentioned, we wanted an evaluative model. We wanted to use the mediation. We knew both parties went into the process prepared to invest a certain amount of time and a certain amount of money. And neither party expected it was going to work miracles. And to answer Kevin's question, actually, we didn't settle. But then paradoxically, the parties don't consider it, or at least speaking for my clients, they don't consider it to be unsuccessful. Because in going into the process, the expectation was not necessarily that you would miraculously settle. The expectation was that you would narrow your differences, that you would somehow still move towards narrowing differences, so that by the time you had to go to some kind of binding process like arbitration, maybe the issues have reduced. And as Junsang said, to pay for a trusted neutral with a good specialist track record in this sector to give a view and probe the evidence of each side. And there was a little bit of process strategy in it, in the sense that I think for each side, they wanted to see a decision maker. And they also wanted to be able, sometimes for the stakeholders, whether it's on our client side or the opposing side, it's useful for people to kind of switch on the lights and see the truth about how good their evidence is or is not. mediation has an ability. Kevin and I are doing a panel on Friday, and we'll talk about innovation, but there's some magic in just throwing all your evidence on the table with the spotlight, nothing to hide. It's all there. Is that the best you've got? And that's what mediators do. So that was a very useful exercise, and that the parties make themselves a little bit naked. They go in and be prepared. That helps you to refine your case. So in a sense, ironically, we didn't settle, but the parties think it's success. And then one more point, which the mediator taught the parties, which is sometimes in very difficult cases, it is a continuum. So you don't settle today, but that's only because you have a time limit. Actually, of our 5 days, the first day was spent building rapport. But by day 4, we actually had a term sheet for settlement. We just couldn't settle because by day 5, the appropriate level of decision makers, at least on one side, had not come to the table. So who's to know what's going to happen next? And then what the mediator said was, you go off and do all the various things you have to do, but if you need to come back to me, come back to me. So the chapter is not closed.
Thank you, Yu-Jin. Actually, my experience, I talked about 4 cases last year, and 2 cases actually settled. As counsel, we sometimes disappointed to see the party settle the case. But it's the other 2 cases. The one case actually both cases we failed to settle. Our client is quite happy with the result. Notwithstanding the case is not settled. And actually the interesting thing is one case actually they actually settled later. Meaning actually Yu-Jin talk about the time limit. So we have the 2 days, the mediation, and the party tried to agree, we failed. But actually parties continue to discuss while the arbitration is still preparing. So we're just about to file arbitration, and parties finally settled the case several months after that. So this shows that the mediation still is quite work. And I totally agree with George and the Professor Shin, but trust, because in that case we have the opportunity, we have the trust with the mediator. Mediator say, whatever you're going to say, I'm not going to just delay all your message to the other side. Just it could be delay this message to the other side, or just like something you just want to test your evidence to us. So that kind of trust is quite important, quite effective. So I have quite positive experience with this, the mediation, actually satisfaction with the mediation process, as long as the process is properly managed. George and Junsang, you want to share more about what happens if the mediation fails before you move on the different issues?
As I mentioned before, I think that I already mentioned that as to that point, if it fails to reach settlements through mediation, but we can get a lot based on the understanding the other party's position, and seeing that case very objectively. And sometimes it caused a delay, but we can arrange or manage the case related to the arbitration or litigation by setting up a very tight schedule or non-delayed procedure. So that's not a problem, I guess. So, but we don't concerned about, you don't need to be concerned about the failure of mediation generally. And I want to make one point with regard to that previous one, that I think that the role of mediators can be written in any form, like a guideline. I think it can help lawyers to understand the client to approach mediation. And so we can explain like this, that the mediators can play a role like this, and so you could be comfortable that they cannot render any kind of decision unless you agreed. So that's the one benefit of the writing the role of mediator, and the other one can be the reducing risk of the ground of refusal, because sometimes probably the mediation is the very easy mechanism to be enforced, but sometimes it can be challenged. So we need to prepare that situation. So if we get a role of a mediator, we can reduce the differences, how to approach the mediation by mediators. So that could be a good way to make mediation thrive in the future. I don't know how to prepare that kind of guidelines, but probably SIMC and other institutions can do properly in due course. Yeah, that's my point.
Thank you, Junsang. George, you want to have any comments?
Yeah, I mean, the statistics are that, at least for us at SIMC, 75% of our cases are resolved, usually one day. So you can see, and I think globally it's usually 67%. So when parties come for mediation, I think there's a good chance of it being resolved already. Now, what about the 25-30% cases that don't resolve? I think for us, our target, our goal then is to make sure that the parties feel at the end of the mediation, whether they settle or not, they feel that the center has provided them with a good process. Okay, so for me, that is the criteria. At 4 o'clock, 5 o'clock, if there's still no settlement, I ask the parties, should I be doing something else? You know, what would you like me to do? Some cases, let's face it, some cases cannot be resolved, right? Because the gap is too big. It's too much emotional baggage. Sometimes there's a third-party funder. It makes it very difficult. So let's be realistic about that. But parties at the end of the day, and we have a feedback form, we ask the parties at the end of the day, you know, are you happy with the conduct, the performance of the mediator, with the center's preparation, the process? And if they say yes, even though they haven't settled, I would consider that, you know, a success in a certain way. But having said that, coming back to the stats, I mean, people want their case to be resolved. Many cases that I've done don't resolve on the day itself, but get settled like 2 months, 3 months down the road. Okay. This morning, actually, I can tell you, I received an email from a lawyer, mediation which I did like 6 months ago. We didn't settle. It was an Indonesian party, the Singapore party, but lawyer wrote to me and said, you know, we settled and we thank you for laying the foundation. So for me, that is success too, because the mediation has helped provide the impetus, you know, the motivation for them to settle later. And like Yu-Jin says, you know, parties know what the differences are, or like you say, you put everything down on the table. It helps them. So we have quite a number of cases where people settle down the road, or even if they don't, if they go to arbitration or court, the legal issues have been narrowed. And again, coming back to the theme of Asian mediation, Asian parties like the mediate. Sometimes they come wanting to know the media's view of the case, right? I think that's very natural. I mean, the lawyer has been working hard for them, but you know, we lawyers, when we take on cases as counsel, we come to believe our client's case so much. So they want to have somebody else's view, somebody independent, somebody without a direct interest, except to try and settle the case. And so I get that question a lot. And the Western model of facilitative mediation sometimes doesn't work, totally. So if an Asian party asks me, I mean, I will do this only in a private session. I will not say you've got a good case or a bad case, but I will raise the right flags. Sometimes it's a good flag, sometimes it's a red flag. And they can read your body language, and then they get a hint. you know. So I think that is some value we can bring. And this model, I think the Chinese, I know mainland Chinese people, they are very used to this kind of model because arbitrators used to mediate for them, or judges even do that. I think for the Japanese, the Koreans, you maybe Professor Shin, you tell me, but I think that model will have more resonance with you all.
Actually,
With the Asian way.
actually, because we have privilege having the chairman of this arbitration festival, Professor Shin here, because he has extensive experience in both commercial and investment treaty arbitration. And there is a lot of discussion about the mediation in the investment treaty arbitration. So I really, we never discussed it before, but I want to hear from his view. What is his experience or the perspective that the mediation in the investment treaty arbitration would work, or the commercial arbitration?
I think certainly there is a high hopes that ISDS system would benefit from the mediation, because now some of the cases we know really the cost of arbitration is very high, and also the political controversy is very, very sensitive. But I think that to be short, really the chance of successful mediation in investor-state arbitration is relatively smaller as compared to commercial arbitration or commercial dispute. That's because of the basically concern of the public officials for later criticism, or sometimes they may have to worry about their career after they settle. They decide to accept settlement, and then once there is a change of administration, and later they will be on hot spot. And also because of the public scrutiny of the cases, and also sometimes national pride. So it's very difficult to settle once the arbitration is filed. But as in our recent Korean case, if there is a very serious talk at the very early stage of dispute, before it becomes national political agenda, then there is quite a good prospect for success. So, and also we should be very cautious in preparing a very elaborate protocol for mediators and also procedures. Otherwise, all the procedures can be attacked by the civil societies and opposition political parties. So a lot of delicate and elaborate thought should be embedded in the protocol, if any.
Okay, thank you.
On this point,
yes,
if I may, Kevin, it's something that came up in my case actually, and it's something that came up also through SIMC and some of its trainings, which is the concept of co-mediators. In certain situations, it is useful for the parties to invest in more than one mediator, and have this idea that one mediator can focus on particularly technical or industry-related issues or legal issues, something that is enumerate, so number-related issues, so you get to a quantum. And you could have another mediator that's more skilled in the facilitative aspect, or maybe is culturally more familiar, or in an ISDS investor-state dispute resolution case, could be politically connected and therefore neutral, more from the diplomatic circles or government circles. it's something also to think about. It's not necessarily just one mediator.
Okay. Actually, it appears to me that mediation is more possible with ad hoc agreement rather than embedded mediation agreement in advance. When parties consider mediation, actually, we already talked about the SIMC's assistance and availability of technical assistance and experience. We talk about venue. I'm wondering how much important, or the venue, for example, Singapore or Korea, for example, the Singapore Convention actually matters where the mediation would take place. At least the perception and reality enforcement, actually. I understand no enforcement yet under Singapore Convention, but it will matters when the Singapore Convention really apply. Then the place of mediation actually matters, and also which organization they're going to use also matters. Any views on that point, George?
Okay, I'm glad you all raised the Singapore Convention on Mediation, because I was involved in the deliberations at Hun Trial for 4 years. And I'm so glad Korea signed as well. So it's not, I mean, I'm proud to be a Singaporean, but it's not just about Singapore. I think for me, the convention, at least for me personally, I wanted an Asian country to take it on. And that's very important for us to show that we are active in this. And mediation is mediation. So, but it's garnered so much support. Okay, we had 46 countries who signed it, and now there are 53 countries. 46 signed on the first day. Now we have 53 countries. It's been ratified by 6 countries, and now it's come into force just in September the 12th. Okay, so actually this has also, I mean, Yu-Jin mentioned this earlier. This has also given a lot more attention to mediation. And many countries are now interested. Okay, so Kevin, to answer your question, enforceability is important. Can you imagine the arbitration without the New York Convention? No, not possible. But the convention is very important for international mediation, for cross-border disputes, because it gives it teeth. And under the convention, yes, you go to the country where you want to enforce the settlement agreement. And if that country is a signatory, then you can enforce it if you meet all the requirements under the convention. So I don't know whether, I hope that answers the question, but I'm hoping, since it was raised, and Junsang, I think you wanted to say something about it, that I understand Korea is taking active steps to ratify it, because I think that's really necessary. Once you get enough countries to ratify it, then it can really become effective.
As to the ratification of the Singapore Convention, among governmental agencies, the MOJ, Ministry of Justice, is very active in making a new legislation. And so due to COVID-19, the process has been delayed somewhat. But in Korea, the MOJ has initiative about that. And so we can get a good results in the near future about ratification and the new enactment of law. And so I think that's a very natural in Korea, because the MOJ has a lot of power to make the mediation thrive, because the main body of government to support mediation arbitration, as you may know. So I think that's very natural process in Korea. So.
Okay, thank you. I reviewed the questions proposed. I think we covered almost everything. But there is some question about the mediation where the mediator makes some recommendation, written recommendation, or just like decision. It's more like adjudication type of things. Any particular comments that adjudication could be, for example, the mediator make a recommendation or any type of decision, and then the parties will bring that, they can agree then, or if they disagree, then they can bring the case to the court or going back to the arbitration. Then the mediator's view can be considered by the arbitrators or the court in the future. In case of expert determination, for example, in the letter of credit dispute, you see that expert determination is quite effective, actually almost binding to in the certain code. What is the experience with that? Anybody?
Well, in the course of the narrowing of issues in my mediation, it certainly could have come about, but I think the mediator is very careful to say that if you come to any agreement after being inspired by something that the mediator has said, it's not a determination by the mediator. This is your agreement. Interestingly, our virtual mediation took place before the Singapore Convention was actually ratified in September. So ironically, we discussed the convention, but we decided that it didn't matter. In fact, remembering that our arbitration seat was London, we deliberately said this is delocalized mediation. It's got no seat. If we had been able to come to a settlement, we would have put an arbitration clause into the terms of agreement. So really no issue. But there's one question from the attendees, or maybe more than one, where they ask about whether there's an impact if the parties were able to choose their mediator or not. And I think one guest has said that in India, they're not allowed to choose their mediator. So does that affect the success rate or the quality of the mediation? In my case, surprisingly, one of the things the parties could agree on was the mediation process, the center, and the mediator. We actually agreed out of a list that SIMC drew up. And that made a difference in the sense that we had short time. Everybody was prepared to trust the mediator. But in theory, so long as your mediators are well experienced and trained, it shouldn't matter that you don't get to select that person. But I think if you do get to select, then there's that element of trust in that person.
Thank you, George.
Yeah, it's quite a good question that Yu-Jin has raised, or a good issue. For me, actually, the choice of the mediator is very, very important. People don't realize this. Now, people will just go by word of mouth, let's appoint this person. But I think the value of having institutional mediation, having an institute to support it, is for the institute to help parties select the right mediator for that case. Because every case is different, and all the mediators that you have in your panel will have different skills, different experience, different cultural background. So to me, that is actually very important. That's a role that institutions can play, and not just leave it to the parties. The parties decide at the end, but they get help from the institute. Okay, Kevin, the earlier question about that clause where the mediator is asked to make a decision of sorts, okay, or his or her opinion. I've come across that kind of clause. It could be binding or non-binding. For me, if you ask, because I was trained in the facilitative mode, the Western model is no, okay. But I think in the Asian context, and if both parties want it, I think we should be able to be open to that kind of concept, but make it very clear. If you give me confidential information, I'm going to use everything I know to make a decision, whether it's binding or non-binding. But you've got to be very careful. Okay, if the confidential information is from one party, that stays confidential. That's why it's difficult, and that's why I think personally the expert determination, or what we call neutral evaluation role, is better. That we offer to the parties, get somebody else to give you your expert determination. Okay, and then that gives you a chance to come back to me as a mediator if you want to. Because once I make a decision or give you an opinion, one party may see me siding the other, siding the other party, and then that puts an end to your trust or your neutrality. So I would rather try and persuade them to get somebody else like Kevin Kim to do the neutral evaluation, and then you come back to me if you want to, which is what I did in that case, and they agreed. Yeah.
Okay, thank you very much. Actually, we are running out of time, so but we have quite. I'm quite happy to make ourselves cover the all important point you wanted to cover. One of some takeaways from this discussion is that mediation became popular. It's getting more popular in the future, and particularly in the pandemic situation, together with the virtual mediation, possibility, that proved that virtual mediation actually work. In a sense, more effective than the in-person mediation. So we can do the both virtual or hybrid or the in-person mediation depending upon the situation. So we now have another option to the mediation by virtually, and also we have Singapore Convention, and the Singapore Convention have invite attention from the parties about on the mediation, but also just have some guarantee for the enforcement of the mediation result or the agreement between the parties. So that is quite the phenomenal development, particularly in Asian countries. And we expect more mediation in this region. And then the other thing actually we all shared today was that it will be more persuasive the parties accept mediation when the parties have actual experience with that. So parties have quite positive experience when they have actual experience. Maybe we can share our experience with others, subject to our confidentiality obligation. We can share our experience with others that what makes the mediation actually possible, what makes mediation is not possible or difficult. Because the mediation really depending upon who mediate and how we mediate. When you have a good mediator, reputable, fair, and experienced mediator who can deal with the mediation properly, and the parties also have properly advised by the council and the party representative properly prepared with assistance of the mediator. Also, with the proper assistance from the institution who can accommodate technical assistance and in the other arrangement, in particular, appointment of the mediator, a good mediator for the case. So I think that is we learn or we emphasize today. With that, I appreciate for everybody for their participation. And I understand everybody busy, particularly Professor Shin. You're extremely busy this week. Thank you very much for your attendance all through this mediation session. We are very honored to have you in person.
My pleasure.
And George, I know you, Sam and Yu-Jin, you are a great lover of Korean and the Korean culture. So we hope we can continue the joint effort to promote mediation in Korea and Singapore and overall in Asia. And Junsang, again, thank you very much. You have a lot of things, including your office management. But I appreciate your participation and sharing your experience. Thank you very much.
Thank you.
Thank you. Thank you, everyone.